Good morning, everyone, and welcome to our Beasley Allen webinar series. Today, we're going to take a deep dive into trucking accident cases and negligent security litigation. I'm David Byrne, and it's my pleasure to introduce our speakers for these important litigation topics. Today, Chris Glover, Warner Hornsby, and Key Lamberth are going to talk with us about the complex task of investigating and preparing trucking accident and negligent security cases. They're going to explain that just beneath the surface, these cases present a web of legal nuances and evidentiary considerations that are most unusual for any type case. And they're going to discuss the latest litigation and investigative trends for trucking and negligent security cases. So while we're waiting on the last of our registrants to join us, let's take just a few moments to meet our three speakers. First, my friend and partner Chris Glover is a longtime leader in Beasley Allen's personal injury and product liability section, and he currently serves as the managing attorney of our Atlanta, Georgia office. Since joining the firm in 2008, Chris has dedicated all of his time to protecting the rights of survivors of catastrophic personal injury and victims of wrongful death. To date, Chris's clients have received verdicts and settlements totaling over $300 million in everything from defective product cases, car accidents, commercial truck accidents, workplace accidents, and aviation accidents. Chris has also been a major leader in some of our most important professional associations. Among other things, Chris has served as the chairman of the American Association for Justice's New Lawyers Division and the Emerging Leaders Division. He's also served as president of the Southern Trial Lawyers Association. And last but not least, Chris currently serves on the Georgia Trial Lawyers Association Executive Committee, and he's the past chairman of the Georgia Trial Lawyers Association Education Committee. It goes without saying, Chris is a huge asset to Beasley Allen, and we are so happy to have him with us today. Next, my partner Warner Hornsby is a member of Beasley Allen's personal injury and product liability section. Warner serves as a principal in the firm's Montgomery office, where he specializes in cases involving serious injury and death due to automobile accidents, dangerous machinery, defective products, and negligence. During his time at Beasley Allen, Warner has played a key role in the trial and settlement of numerous complex injury cases. And, not surprisingly, he's been selected to the Mid-South Super Lawyers Rising Stars list every year since 2019. Currently, Warner serves on the executive committee for the Alabama State Bar's Young Lawyers section. And during his time on the executive committee, he's overseen the pro bono program for that section. Warner is a fantastic attorney, and we couldn't be blessed with a more knowledgeable person to talk with us today about trucking accident litigation. Last but not least, it's my pleasure to introduce another member of our personal injury section, Key Lamberth. Key works in the Atlanta office of Beasley Allen, where she specializes in cases involving negligent security, premises liability, and also trucking accidents. Key earned her law degree and her undergraduate degree from the University of Alabama, where she graduated summa cum laude. In law school, Key served as the editor for the Journal of Law and Psychology, and she was a very active participant in the school's trial advocacy program and its many trial competitions. Key is also a tremendous asset to our firm, and we are so delighted to have her here with us today to specifically discuss negligent security cases. So, before I turn the program over to our three speakers, I just need to go over a few CLE housekeeping notes. First of all, today's webinar has been approved by the Alabama and Georgia State Bars for 1 hour of CLE credit. In order for you to receive full credit for attending, you've got to stay on for the duration of the program. A link to today's presentation was included in the Zoom confirmation email you should have received when you registered. But by the end of this week, you'll receive another email with a certificate of attendance and an updated presentation and video link. You can email that completed evaluation form to webinars@beasleyallen.com. This webinar is being recorded, and for those Alabama and Georgia attorneys who happen to be participating by phone, please email us your name, your phone number, and your state bar ID number. Send that to webinars@beasleyallen.com. That's going to help us ensure you receive full CLE credit today. Also, be sure to check out the events page of our website, beasleyallen.com/events, as we'll be adding more webinars throughout the year. Finally, if you have questions during today's webinar, I want to encourage you to use the question and answer feature. That's the Q&A feature located at the bottom of your screen. We're going to set aside time at the end of today's program to try and tackle all the questions submitted by our viewers. So with that, Chris, Warner, and Key, let's get started.
Welcome, everyone. We're so glad to have you join us on this webinar here today. We are excited about the topics we have together to present to you. I and Warner have done a lot of trucking cases over our career. One of my first cases I tried close to 25 years ago was a trucking case. I was fortunate enough to get a verdict in that case and continue to work on those cases throughout my career. I wrote a trucking book that's now a little outdated. I guess it's 15 years old. Probably should rewrite that. And I've just continued to stay really interested in that area of litigation. Warner's done the same. He's tried cases, gotten verdicts in trucking cases. He's handled a number of them, got tremendous results, and it just does a fantastic job. And then Key's going to talk to us about negligent security litigation, something I'm interested in hearing about more. So it's an area of the law that I don't typically practice in, although her and my law partner, Parker Miller, do a fantastic job and couldn't be more pleased with the work that they've done for their clients and the help they provided to hurting families. And so anyway, with that said, we'd love to get started. Warner's going to start us off, I believe, talking about trucking cases. So Key, if you can, bring up the PowerPoint and we can get going.
Thank you, David. Thank you, Chris. I appreciate the introduction. Yeah, like Chris said, we're going to start off with the trucking side of things. And you know, it's interesting when you start looking at a webinar, what does a deep dive in trucking litigation mean? And so what I thought I would do is start with a case that we tried recently in this January docket in a county in Alabama called Lowndes County, which is a really good venue for us. But this case had some issues, and it's not a perfect case, which is why I thought it might be a good case to talk about, to kind of demonstrate, you know, what we're looking at, what we're trying to do, what our goals are, and how we kind of get there when we're going through a trucking case. And so we're going to go over some general things first, and then I'm going to go talk about that case more specifically and walk through, you know, what we faced, what we did. So the first question that, you know, that always crosses my desk when a new case comes in is what are we trying to do with this case? What are we trying to prove, and how are we going to do that? And in a lot of ways, a trucking case is the same thing as a car wreck in terms of you're just trying to show liability and damages, right? But there are significant differences when it comes to a truck, and it's far more complicated because there is a more complicated and more significant set of rules. And there's a more significant set of rules because a truck is far, far more dangerous than a regular car on the roadway. And so how do we go about showing liability? Well, there's three general, you know, big overview areas that we're going to look at. First off, general principles of negligence, right? I mean, the same things that make a regular driver negligent make a truck driver negligent. It's just as there's also more things a truck driver has to deal with. The second thing we're going to look at is are those regulations, the Federal Motor Carrier Safety Regulations. That's where a lot of your liability is going to stem from. And the third thing, for the most part, is going to be your state's normal, your whatever state you're in, whatever their CDL manual is. That's going to go through and talk about all the requirements that the driver has to follow to have a CDL and to keep CDL and to drive as a commercial driver. But it's not just those three things that we're just trying to show the driver did something wrong. The most important part of any trucking case is making the liability relate to the company rather than the driver. So right out of the gate, I wanted to talk about that because that is the most important part, I think, of the liability side on any case. And to give you an example of what I mean by that, I have pulled from the Federal Motor Carrier Safety Regulations Handbook, which I have a May 2021 copy. I'm not sure if that's the most up to date, but if it's not, it's pretty close. J.J. Keller produces these things. Everyone that's involved in trucking should go and buy one of these manuals. But under section 395.8, which is the driver's record of duty status, that, you know, they have to have the logs and record all the things they're doing on duty, you know, not on duty, but not driving, and then off duty. The DOT gives guidance in the handbook that answers questions that a company, might have and gives guidance from the DOT on it. And one of the questions is, what is a carrier's liability when the drivers falsify records of duty status? And the guidance from that is, and I've got it written down, but I'm going to read it anyway. A carrier is liable both for the actions of its drivers in submitting false documents and for its own actions in accepting false documents. Motor carriers have a duty to require drivers to observe the FMCSRs. Now, I'll put that down there because I love that language. Even when the drivers are falsifying records, it's still the company's responsibility to make sure that they are overseeing their drivers to make sure they're doing all the things they're supposed to be doing correctly. In my experience, most of the time, the drivers are not falsifying records. They're doing the best they can. And so you have this weird situation where a driver is really reporting what they're doing wrong to the company, and the company's not doing anything about it. And so even when it's falsified, they have a responsibility. They certainly have a responsibility when the guy's reporting what he's doing wrong. And so that the focus of the case is basically captured in that little segment and that guidance. And it is, how do I make the carrier responsible for this? Key, if we can go on to the next slide. Thank you. All right, so proving your case. What I've got kind of a weird headline there is, it's not the driver's fault. And of course it is the driver's fault, and it's okay that it's the driver's fault. But when you're starting from how do I prove this case? How do I make this case the most valuable case I can? You should have in the back of your mind everything the driver did wrong. Why is that not his fault? Why is that the company's fault? Everything that the guy does wrong, every violation he makes, every CDL instruction that he doesn't do right, what did he do, and why is that not his fault? And most of the time what we see is that these CDL drivers, they go to a school for 2 weeks or 1 week or whatever it is, they get their CDL, years go by, and they haven't really done they've never done anything on their own, right? So there is no overview of the safety. There is no, reaffirmations of all the things that are in their CDL manual unless the company is doing it. And the companies almost never do it. So here's what we're looking at. You're taking the CDL, and the CDL manual is a really good place to start, because that gives you the baseline for things like overdriving your headlights, right? I mean, it takes, if a regular size, a full size 18-wheeler is driving down the interstate at 55 miles an hour, it's going to take him 450 feet to stop. Generally speaking, that's the accepted idea. And the high beam headlights at night shine between 350 and 500 feet. So if you've got a truck driver who's driving on an unlit road at more than 55 miles an hour, he's probably overrunning his headlights, even if they're high beams. And so you take those kind of liability issues that you're going to find in the CDL manual, and he did that wrong. And now your question is, why is that not the driver's fault? And the question always needs to be returned to, because the company didn't give him the training or the opportunity or the guidance, the review that he needed to be reminded of, to be trained on all the things he needs to do right. Right? What kind of training? I wrote down a few of these ideas, right? What kind of training did you receive? How many times a year, a month, a quarter? Did your company safety or management team ever discuss that thing that led to this wreck? Yearly reviews, post-wreck investigations. We see all the time. These companies, they do the bare minimum, right? They get the document that says I did an investigation in the file. But when you look at that investigation, whatever it is, they didn't do anything. They just did enough to make sure that they've got something in the file that they can pass, a facial muster. But the driver will tell you, they didn't really have any real safety courses, or the safety courses that we had was just obey the speed limit and plan your route, So really dig into, what did this company do to give this driver the training and the safety preparation he needed on a regular basis to make sure he was driving safely and obeying all those FMCSA or FFCSR rules.
Warner, if I could jump in real quick, I couldn't agree more about making the case about the trucking company, what they did or did not do. And I think the key in doing that is knowing what they should or should not have done. And you have already mentioned the FMCSRs. Well, you've got to know those. You have to know those. They cover such important topics, such as hours of service, maintenance, pre-trip inspections, your qualifications to drive. I mean, your health, the driver's health. I've had cases involving all of those issues. Had cases where the health of the driver was the issue. He shouldn't have been qualified because of that. I've had issues where his driving record should have disqualified him. I've had issues where the hours of service should have disqualified him. But you've got to know those regulations. And if there's an FMCSR violation, that's a great thing for your case. But there's not always an FMCSR violation. It may be an industry standard, and Warner's already mentioned that, such as outdriving your headlights. There is no FMCSR on outdriving your headlights, but there are industry standards. There's Smith system training. A lot of trucking companies have internal training for those type issues, like parking on the side of the road. There are FMCSRs on parking on the side of the road if you put your triangles out, and it's got time limitations, things like that. But you wouldn't think about this, but there are a lot of companies who absolutely prohibit it because it's dangerous. They say you're a sitting duck. That can be a violation of an industry standard. And so understanding not only what those FMCSRs, but what are the industry standards? And it takes some time to get up to speed. There's a lot of resources out there that are available to share. I've been collecting internal documents from trucking companies for 20 years. I save them. I've got boxes of them in my office, and I go through them on each case to say, well, what am I missing? But anyway, I couldn't agree with Warner's exactly right. That's what you have to do to get these cases in the best position.
That's right, Chris, and thank you for jumping in and talking about that. I know sometimes I kind of steamroll through some things, and unfortunately, I know when I was younger, I was looking for the quickest way to learn anything I could, and unfortunately, there is no magic bullet for that. You've just got to read the FMCSR. You've got to go through the CDL manuals. You've got to go through and talk to lawyers who have done this and make sure that you know all the things that apply as in terms of standards to your wreck and to your driver. And so, there's no secret for that. It's just hard work and knowing the law on your case. And, what applies and when it applies is going to be different based on what kind of carrier you are and interstate. I mean, are you only staying inside the state or not? Those are just things you need to look at and understand. Key, can we go on to the next slide? Okay, so I thought I'd demonstrate in real time, in real practice, what how I'm talking about making it about the company. I'll talk about how we actually tried to do that in a real life scenario. This case is settled, and we have a settlement agreement that is confidential as to the names of the parties, but not as to the amount of the settlement and the facts that was actually tried in open court. So I'm not going to do anything to tell you who these parties were, but I think just talking about the facts is going to be perfectly fine. So in my case, the company that we sued was a shipping company that hauled, for the most part, these shipping containers on trailers. And you can see that in the picture on the left. And what happened was, as their driver was turning left, if you're looking at my screen, he's moving from the left to the right to turn into the lane of travel going towards the top of the screen. So he's making a left-hand turn coming from the left side of the page, turning left up to where the drawings are. As he's making that turn, his trailer just falls off of his truck. Now, if y'all know anything about the way that mechanism is supposed to happen, so a lot of people will tell you that if a truck is properly latched on, that's the strongest point on the truck. I mean, it's a cold steel latch on a huge steel little hook that goes around it. And I found videos in preparing this case where empty trailers were parked across a railroad track, and the heavy truck was sitting just off the track, but the empty trailer was on it, and the train comes by and hits it, and instead of just pulling the trailer off, it actually drags the entire truck with it. I mean, those things don't just come apart unless they're not properly attached. So we've got a trailer that just completely fell off while he's making a left-hand turn. That's obviously something wrong with how he attached that trailer to the truck. And this diagram was drawn by the defendant, the driver. The big straight black line is where he says the shipping container came to rest across the roadway. So if you can imagine, this is at night on a two-lane divided highway, not an interstate, but a highway with no real lighting around. And the shipping container that you can see on the left, or something very similar to that, was just sitting in the roadway. It would have been a little further down on the front because it came off of the truck. It wouldn't have had his legs down, but that's basically what it looked like. The black X is where the guy said he stopped and saw that his trailer had become disconnected. And he said he put out his triangular devices like these little bitty X's on the bottom, just straight across about 10 or 15 feet in front of the front edge of the trailer. Then he drove up the road and just left the scene. Now, in reality, I really don't think he put the triangular reflectors out at all. He just drove away and came back and parked on the other side of the road. My guys were coming back from a hunting trip. I had two older guys who, one of them was already disabled due to a diabetes condition, and the other one had, I think before the wreck, he had already had about 21 different injections in his neck and back. He had an extensive pre-existing injury list. But they come up on this trailer without any warning and swerve to the right, barely. I mean, they almost miss it, but they don't. He kind of sideswipes the thing and they come to rest down in the shoulder of the road over there. And basically what I had was soft tissue injuries, herniations and aggravations of pre-existing degenerative stuff in the neck and the back. They both ended up having surgeries. One of my clients died before we could get to trial. Pre-trial, the offer to settle was something in the $150,000 range. We tried this case for 3 days. We had a great county, and there's no question about that. But we tried this case for 3 days. It mistried over my strong objections. And about 2 weeks later, they paid us their policy limits of $4 million. And I think the reason that they did that was because we were so effective at applying the liability to the company. The driver was a very old African-American man who had since retired. He was a war veteran. There was a lot of sympathy, especially in that county. There was a lot of sympathy for that man. If I had made the case about him, right, taking away the good ideas of just putting it on the company anyway, but if that case had been about him, we would not have been making a winning argument. So the case had to be about the driver. About the company and not the driver. So every single violation that we have here, and we have a lot, right? He didn't put his triangles out, but even if he did, he says he did it in this way, which is not correct. On a one-way lane like this, those triangles are supposed to be 10 feet behind the truck, then 100 feet behind the truck, and then 200 feet behind the truck. The idea behind that, right, is that gives you an extra 200 feet of reflective warning so that you can have time to stop before the dangerous part. And him putting those reflectors 15, 20, 10 feet in front of the back of the trailer did nothing to help the oncoming traffic. Number two, he left the scene without any kind of illumination. Now, this isn't a direct FMCSR violation, but the rules do make it very clear that you need to illuminate anything that is in the roadway. If you are in the roadway, get those flashers on it. Make sure that your running lights are on. Whatever it is, make sure there's a light on it. Well, when his trailer got disconnected, he couldn't, there was no light attached to the trailer itself. So we argued that he should have, if he had been properly trained, he would have known or should have known that he needed to get around and turn his headlights on it, somehow get it illuminated. And then we had a significant violation with the way he did his pre-trip inspection, which did not catch the fact that he was improperly linked to it. And so, Key, let's go to the next slide. And so what did our cross-examination look like of that man? And how did we start going through that case? And what we were able to find out was that after 5 violations in a row of not doing a pre-trip inspection on his logs, the company never spoke to him about that. Never, not at one time did the company ever mention that he had had a violation for his pre-trip inspections. They tried to play it off as, you know, this isn't really mean he had a violation. He just failed to press the button. I'm sure he was doing his pre-trip inspections, but they never checked. The way he put his triangles out, you know, he got confused because the rules say, you know, when you park on the side of the road, but they also say when you stop in the middle of the road. And he said, well, I don't know what to do when we drop a trailer in the road. Well, so that question became, well, did the company ever train you on how to handle when you break down in the road or when you drop something in the road? You know, what do you do in that circumstance? Company ever do anything about that? He said, no, I've never got any of that kind of training. He rarely, his year-end reviews, if they happened, were very minimal. And so our cross of him was absolutely, you did this wrong. This was not correct, and this was wrong. And the very next question is always, did they do anything to train you on that thing you did wrong? And importantly, I think if they had trained you, would you have done it the right way? And of course, he's going to say yes to that, and he did. And so our cross-examination of this very sympathetic man, we got all the things we needed to get. We showed that he was negligent and even wanton. I mean, he was absolutely reckless in this, but that recklessness wasn't really credited to him by the jury. It was kicked off to the company. And we followed that up. And this is very important. I think we didn't hire an expert in this case. I didn't feel like we needed to because we had deposed the corporate rep, and I used him as our expert. Like that guidance question I told you back in the very first slide, every single rule, every single violation, every single standard that I wanted it to be. I mean, I had my books, my FMCSR, my CDL manuals to back me up, but I used their corporate rep as my expert on what they should and should not have done. And then we very clearly demonstrated through the physical evidence and through his testimony that they just didn't do that. And they didn't give him the opportunity to do those things. And that is what led to this wreck happening. And Key, let's go to the next slide. In keeping with the corporate rep being the expert and being the focus of the trial, it's important to use your government resources because there's a lot of really, really good things that the government does to help you with your case. This is a more recent snapshot of the same company, but you can see it says the out of service violations or percentage is right over 20%. At the time of my trial, or at the time of the wreck, it was closer to 23%. Now, for the most of the time I had this case, you know, we obviously looked at this and knew this. I was a little bit nervous about using this because it says right there, the national average is 22%. So they're right there with it. When I tried it, they were a little bit above it. Now they're a little bit below it. But let's think about what that really means, right? That means 20.1%. 1 out of every 5 trucks that they put on the road that's examined by an independent examiner or a police officer had some sort of condition that made it too dangerous to drive. And hey, you can't drive this on the road anymore until you get it fixed. 1 out of 5. And my case, you know, was very, very much focused on a pre-trip inspection issue that should be catching all these things that make a trip or a truck dangerous. And they in my case, they were closer to 1 out of 4, but still 1 out of 5 is plenty good. The fact that he was going to be able to say, well, we're right at the national average, that didn't bother me at all once I started thinking about it. I don't care. I mean, in fact, I wanted him to say that because that gave me the opportunity to introduce other trucks, other companies who have much better scores. And it gave me the opportunity to ask him questions that made it seem like he just didn't care. For example, are you telling me that you're telling this jury that it's okay for your trucking company to be unsafe just because other trucking companies are unsafe too? I mean, this national average thing is just not a good defense. So use these government resources, and that I'm telling you, we asked that question. I gave it a little more embellishment in trial. Because of this kind of record from the government. This is the Safer Web company snapshot. I'm telling you, that question destroyed him. I mean, the juror just looked at him like, like he was the craziest person they'd ever seen. Of course, you can't blame it on the national average. You've got to be better. And so we transitioned how bad their driver was in this one specific instance. And through the questions about his conduct and why the company didn't help him, combined with this government, 1 out of 5 trucks, there was no question in those juries' minds that this was an unsafe company. And that is what we were trying to do. And that is the goal we were trying to meet. And through those resources, we were able to meet it. And I believe that's why, even though the case mistried, they paid us the policy limit so quickly thereafter. Couple other things that I want to talk about. I know we're kind of running out of time before we need to go over to the negligent security. Key, can we go one more slide in? One thing that I think we can't ignore in a trucking case, even though trucking cases have all these regulations, all these rules, all this extra work you have to put into to make a really good liability case. Trucking cases are only as good as your injuries are. I mean, I don't care how mad or bad the trucking company is, you've got to work up your damages. Punitive damages, which you can almost, I mean, if they've violated a federal motor carrier safety regulation, you got a good shot at punitives. At least in Alabama, you do. And so punitives are almost always related in a jury's mind to compensatory damages, even though they shouldn't be. And a lot of states and courts cap them that way too. So you've got to work up your damages. You've got to spend at least as much time and effort, and in my opinion, more, on your injuries and your damages and what those damages mean. Permanent pain, what that means over the long run, over the long term, to really bring your case home. Just because you've got great liability, you need to work up the soft tissue side. Now, sometimes in these trucking cases, we see significantly horrible injuries and deaths, and to an extent, those sell themselves. But you still shouldn't ignore the impact, right? I mean, you need as many witnesses talking about injury as you can. But I wanted to make sure that we brought this case up because you don't have to have the quote unquote great case to have a great case, right? This case, I had a disabled man and a dude who had so much problems with his back and neck that he'd already gotten like 15 or 20 steroid shots in his back in the 3 or 4 years before that. I mean, this guy's medical sheet was so long. It is incredible how much work he'd already had done. But what did that do? Well, because he'd had so much work on his back, we had an MRI like a year before the wreck. And then we had another MRI like 7-8 months after the wreck. And there was a difference, that his back looked different in just a 16, 18, 20-month period. And the only thing that really happened was there's a truck wreck in the middle. So we were able to clearly show that all of that aggravation, all of that exacerbation was due to this wreck. And so we get to talk about that pain. And of our witnesses, I mean, I think we had 4, maybe 5 liability witnesses. I was going to call twice that, and witnesses related to the injury and to the damages. But soft tissue injuries, as long as they're permanent, right? I mean, you get a sprain, it goes away in 6 weeks. There's not much you can do with that. But you got a permanent issue, even if it's just a herniation. That's worth a lot of money, because pain is worth a lot of money. One thing that I like to communicate, Key, we can go to the next slide. Well, let me go back one more time. One thing that I like to communicate before to all of our young lawyers, we can't tell the jury, what would you accept to trade places with your client, right? And I submit I've never gotten a client enough money to switch places with them, right? And so if I wouldn't do it, why in the world should I be ashamed or nervous about asking for more than that in trial? I just have to do a good job, be a good lawyer to make the jury understand how serious that is. Because if I won't trade places, then why can I say that less than that is fair? And that's what a compensatory damages verdict is supposed to do. It's supposed to fairly and reasonably compensate you. So I'm challenging every lawyer that does a trucking case to really, really work on how can I show and demonstrate what pain over time means, so that I can stand in front of a jury and confidently ask for that multi-million-dollar figure, not because we're greedy, but because that's what pain is worth. All right, Key, next slide. voir dire. I wanted just to take a second to talk about this. Voir dire is one of the most important, if not the most important part of any trucking case, especially in a more conservative county. I'm kind of keeping my eye on the questions, and I see a question about a truck case, whether we file suit and being in a conservative venue. In my opinion, if I've got a permanent injury, no, it wouldn't. It wouldn't make me less likely to file a case in a conservative venue, because I know that I can handle that in voir dire, or at least I'm going to try to handle that in voir dire. And I'm not going to deny a client the opportunity for justice because it might be harder. You need to start first in voir dire. There's a lot of things. Trucking company is a huge industry, right? Everybody knows a trucker, or is a family member of someone who is one. You've got to make sure that there is no bias for trucking companies in your jury in voir dire. You've got to make sure of that. You're going to hold these jurors to a massive verdict against a trucking company, and you need to ask them that directly. Can they handle that? Do they like trucking companies? Is it okay to hold a trucking company to a different standard than a regular driver? Some people think that's not fair. You need to start laying the groundwork for all of those kinds of differences in voir dire as soon as possible. And once you've identified the issues that are going to be in your case, start asking about how the jury thinks about that issue. You're going to hear that this driver has a responsibility to put out triangles to warn oncoming motorists about car, there's an obstruction road coming up, and we're going to put on evidence that he didn't do that. And does anybody have a problem with holding them liable because that didn't happen? And not only just him, but because the trucking company holding them liable because they didn't put the triangles out. Let's talk about that. And I'm not at all worried about bad answers. I think that's what you're looking for. You're trying to find the jurors who disagree with your theory of liability or disagree with the ability to give good damages. Identify them, get them talking to each other so you can strike them, hopefully for cause, and if not for cause, then strike them with the peremptory challenges. I only have two more slides, Key. Let's go through that last two. Insurance. I just wanted to talk about insurance briefly. What we're seeing more and more is these guys are hiding insurance from us. They're not telling us about insurance levels that they have. They know they have to report the first level, and that's all they tell us. And so, I wanted to just note that if you go to the SAFER website and you look under the insurance reporting, there is a form they have to file, and it's going to have on the site, it's either going to say 91 or it's going to say 91X. If it says 91X, then that indicates that they have a second layer of insurance. So if they only give you that primary level of insurance, and you look and you see a 91X, you need to be on them about giving you all the insurance available. Key, we can go to the next slide. I don't ever settle a trucking case without first making an excess demand significantly in excess of that primary layer, because that should at least get a good attorney to report. And now I can't tell you how many times more insurance is disclosed once I make a legitimate demand or go to mediation and talk about a significant number. I don't settle with the first layer without at least trying to make it the whole settlement conditional upon my being able to sue them again, no matter when, if I find out there's more insurance. And then, always talk to people who've sued companies before and try and figure out if that's the only insurance they have. That ends my PowerPoint slide. Chris, do you have anything else you want to add?
No, I think that was excellent. Thank you, Warner. That was truly valuable, and why we were here today to talk about. Look, we're out of time. 12:40. Key's got a big presentation left. I was going to talk a little bit about tractor trailer collision avoidance technology. It is a very extensive topic, and it would take me some time to get through it. And look, we will do another webinar just on that in the near future, and I'll get with our people to do that. But let me just tell you, one of the things that you run into, and Warner just talked about it, was the fact that we've got limited insurance in some of these cases. I mean, a lot of carriers have excess coverage, but more and more of times they don't. They have $1 million, and when you've got the kind of damages that we see when an 80,000-pound tractor trailer hits your vehicle. Many times, if not most times, you're going to have damages that are warranting a recovery over $1 million. And here's the thing, if you can't get it from the trucking company, maybe there is another angle. Maybe that angle is to go after the product manufacturer. You have to have catastrophic injuries in those cases, death, paralysis, lost limb, some sort of life-altering. It's more than just a surgery. But in those cases, there is an angle for what's called CAT technology. Tractor trailers now should be equipped with automatic braking system, lane warning departures, should be warning for braking in accidents. Autonomous vehicles are here. What are we going to do with those? There's a whole host of topics. And let me just say, our firm is very, very active in those cases. We are very knowledgeable. We're doing those. Think you've got a tractor trailer, you don't have enough case, when you don't have enough coverage, you got catastrophic damages, and you need to look for another avenue of recovery through the product liability claim, then we'd love to talk to you. There can be two claims there. Can be that they had the technology and it didn't work. I love those cases. Or they should have had the technology and they didn't equip the vehicle with it. And since here's the thing about trucks drive so much. They're on the road for so many miles. So you most often have newer trucks on the road. They have to replace them often. That means that they should be equipped with this technology. Newer vehicles should have it. Anyway, that's what I have. Let's go to Key. Unfortunately, I need to log off and go catch a flight. I am in Bedford, Oregon on my way home and want to get there. So thank you all for attending, and I look forward to hearing about Key's presentation. Go ahead, Key.
Thanks, Chris. I'll scoot through, get over to our negligent security. My name is Key Lamberth. I'm in our Atlanta office, and I work primarily with Parker Miller, and majority of our caseload focuses on negligent security, handling complex litigation that often involve complexes in different properties. So this webinar is really just to walk you through and how to build up a negligent security case, what to look for and be conscious of, and ultimately just the key things that are really going to potentially resolve your case. So looking at this first, there's a variety of settings where a negligent security case can come out of. Gas stations, particularly in the parking lot. If you've got a gas station that's in a hot neighborhood, it's particularly a popular space to hang out at, loiter on their premises. If you've got a high crime area or neighborhood, different apartment complexes in a high crime area, and you've got a centralized gas station, you can expect that gas station to have a history of crime. Shopping malls, those are a magnet for crime. Specifically, I mean, if you Google nowadays a shopping mall, you're going to see probably every article is going to touch on an uprise in teen violence occurring at shopping malls. And why? I mean, it's pretty simple. That's where they go to hang out on the weekends. They group up. They're unsupervised. They know that malls are crowded. They can sneak in and do whatever. Other than that, when we had a couple shopping malls cases where it's actually started in the shopping mall and progressed to the parking lot. That's a really popular thing we see often. Nightclubs, you see more and more cases involving nightclubs, most of them shootings. The big question there is always, how is a patron allowed to enter that nightclub with a gun? And then the business properties, same goes, you're having grocery stores, pharmacies, and you want to make sure that your client was coming onto that property to actually purchase something. not loitering around, and we'll touch on that later. Here, I kind of just wanted to lay out what it looks like to prove a negligent security case, kind of looking at the law-wise. You know, what Georgia law tells us we need to prove to be successful for a negligent security case. And as many as you know, the Georgia appellate courts are very active in negligent security cases. The factors that go into proving one of these cases, it's constantly being scrutinized by the courts. So I'll say that it's very important to be up to date on the law. For instance, and we'll talk about this in a minute, the Carmichael versus CVS case, which some of you may be familiar with as well. I've listed here just a couple core aspects to be aware of. One thing that the case law is absolutely clear on is that providing adequate security at all times is a non-delegable duty of the property owner and the occupier. And to me, this is kind of your starting point because oftentimes the property has an owner and an occupier, but also a management company or a security company performing the day-to-day activities on the property. And so what the property or the owner or the occupier will try to do is try and shift the blame to these parties who are performing these day-to-day activities. But as you see, the law is very clear. You can't do that. Another thing is the status of your client. That is right off the bat something you want to establish. If you have an invitee or they are resident, for instance, of an apartment complex, they're an invitee and they have the duty of ordinary care to keep the premises safe. Other than that, again, this goes back to whether they are a resident or whether they're coming onto the premises to provide a benefit or purchase something that puts them in the invitee category. Other than that, they have a duty not to engage in willful or wanton conduct, and you will find that that is an uphill battle that you do not want to climb, but it is doable. And on the flip side of things, you know, they're always going to say that your client was a trespasser. So that's always something to be aware of and looking at the status of your client. Another thing is you need to be aware of what is and what is not foreseeable. You will undoubtedly face this in a motion for summary judgment. It basically boils down to what did the property owner or the occupier know or should have known that the environment on the premises was dangerous, that there's violent criminal activity on the premises, and that those crimes put them on notice that, you know, some action needed to be taken. And I will say that majority of our time could probably be spent on the CVS versus Carmichael case and kind of breaking down what this opinion said and kind of how it changed negligent security cases and what, you know, we had to prove. But I'll just run through a brief couple of points on it that I think are important. You know, before this case, there was a bright line rule, more so a bright line rule in negligent security cases where if you could show that there were substantially similar crimes on or near the premises, you could show foreseeability. Now, with this CVS versus Carmichael case, we've moved away from that standard into this totality of the circumstances. And basically the totality of the circumstances informs the owner and occupier whether a third party criminal act was foreseeable. So it doesn't completely do away with the substantially similar crimes. That's one of the considerations. And you'll see here a couple other considerations are, you know, the location as a high crime area, and the owner's and occupier's knowledge of a volatile situation brewing on the premises. And the court made sure to note that, and this also goes back to the same type of law, that the crimes need not be identical. The proximity, timing, frequency, and similarity of prior acts informed the question of foreseeability. So, you know, this is ultimately a very fact-intensive case-by-case analysis. Probably will ultimately lead to a question of fact for the jury to decide. And breaking down just a couple of those points, I mean, basically, an important part is that you just don't want to discount any past crime that is different from what's happened in your case. If there's even a possibility that it's relevant to the owner's knowledge of dangerous conditions on the premises, you're going to want that. And what you can do is you can establish that there's something about those incidents that relates to yours. And I'll kind of give you an example. If you're pulling call records for a premises, you know, sometimes it might say fight broke out. And you need to go a step further and see that a trespasser actually entered onto the property and victimized a resident. Obviously, the problem there being the fact that a trespasser was able to gain access onto the property and violently attack a resident. The point being, though, that there are plenty of past incidents that can be labeled as one thing, but ultimately can be very important to your case, and ultimately the knowledge that that occupier or owner has. Another point in Carmichael is that you can look at the high crime, you can consider the high crime area. You'll want to pull crime stats from the entire crime area, the surrounding area. We typically pull past incident reports from within about a mile of the property, and we go from there. So I kind of listed here for you a couple of, obviously the investigation stage of these cases is absolutely essential for how you're going to evaluate these cases and move forward. I've bullet pointed a couple of things that I think are the most important steps. And really, we've touched on a few, but having someone feet on the ground immediately when you get this case is really important. And I say that because a lot of these places, especially if you're dealing with an apartment complex, are going to see these cases, say it's a shooting, kind of implode, and then they're going to turn around and maybe they'll put up a security camera. They'll hire on-site security. So you need someone there ASAP before they go around changing anything. Another important thing is a request for those call logs. And call logs, the defense, they're going to fight you and fight you hard to keep all these call logs. Because oftentimes these call logs do not have a corresponding 911 report or a corresponding police report. They just show the 911 call. So all you can see is a call sign, and I'll note that you need to also request their page telling you what their call signs mean. Sometimes they are very clear, sometimes they're not. For instance, if you have a call log and you see a call for service over gunshots fired, it is very, very unlikely that you're going to see an actual incident report filed over that call. And why? I mean, it's pretty obvious, but I mean, no one actually wants to report. They're too scared of the repercussions. They don't want to get involved with the police. So you're going to be left with the call logs and with no report, but you tally those up and all you have to show is that the complex knew about this reporting. You know, and with those call logs, this is where it becomes really critical that you depose residents, you utilize your private investigator, because bottom line is, you know, that if the property owner or the occupier was doing what they should have done, then they should have had a complete picture of what was going on at that property. Another important thing to note is the HUD investigations here. You can find out a lot if they have complied with HUD requirements, if they have sanctions or violations. You learn a lot more about this property, and it gives you a full assessment. They usually send someone to come do these investigations, so you figure out a lot there. Couple of defenses to be aware of, and and I'll go quick. I know we're running out of time, but equal knowledge, the plaintiff or the deceased knew that the person that victimized them or had a personal history with them. They will always say that your deceased or your plaintiff knew more about the situation than the property owner ever could. And one note about that is you have to assume that any information about your client is going to come out. If there's a criminal investigation, which there probably is, there's going to be a point in time where the criminal records are released, or the entire file for the criminal investigation at any time could be dumped on you. Another thing is targeting. The defense is that the incident that happened was impossible to prevent because it could have happened essentially anywhere. And this all kind of ties into superior knowledge and foreseeability. And obviously foreseeability will always be their number one fight. Again, you will encounter that at a summary judgment phase, no doubt. The result here is the same. Target can be personal animosity or, saying that they knew that the victim, dealt drugs and carried a lot of cash on them. They robbed them and they shot them. This could have happened at anywhere, at any time. So this is where understanding the entire incident and how it happened is really crucial. Off property suggests you look at Martin, the Six Flags case in Carmichael. Again, it touches base on whether the owner or occupier had knowledge of a volatile situation brewing on their premises. Trespasser, we talked about this enough. You need to determine early on what your client's status is. And mutual combatant, that's a big one we encounter and one you should definitely be aware of. Second to foreseeability is, did your plaintiff come there to fight? Your argument will always be, well, my client wasn't intending to engage in mutual combatant. He didn't want to fight, but he could see that he needed to protect himself. So it comes down to self-defense. And again, that usually creates a fact issue for a jury. So that's a short breakdown of some defenses. They're also going to look into, your client. Don't take their word. A lot of times you have to ask the difficult questions. We have a lot of minors, cases, death, shooting, etc., where mom may not relay full information of what their child was involved in, and we may not know their background. And I would advise you to run background checks and corroborate their stories and their backgrounds. Because ultimately, if you're down in this situation, I think it's always important to remember that who is in the position to do something about this. Proving your case. We've gone into a lot of this. These are just a couple bullet points that I find are important. Policies and procedures can become your best friend and the golden ticket to pointing to what they should have done to protect the safety, health, and welfare of their residents. Financial records, huge, tell you where they point their budget towards, their intentions, and you need to get a professional to review those records. And lastly, on this, where you see really big verdicts is, if someone is begging for security, you want all the complaints and concerns that the residents are, and this is just a typical marketing, what they tell you you're going to get. Security measures we think are important to implement. This is by no means an exhausted list. And lastly, you really need to be aware of insurance before you do anything. These cases take a lot of work to investigate and build up. They're really expensive, require security consultants, apartment experts, security experts, and a lot of times they have deep ingrained exclusions that relate to your negligent security incident at hand. So that was a quick breakdown of everything, but that's all I have.
Well, on behalf of all our viewers, I want to thank Chris, Warner, and Key for a fabulous presentation. I'm always impressed by the work that my partners do, and I really enjoy learning from them. Now, we have received a few questions during your talk today, and if you'll allow me, we won't have time to get to all of them, but I can tell our viewers that if you have questions about today's presentation, Warner, Chris, Key, they will be more than happy to answer your questions. You just email them, and I know they'll get back to you probably within the next 24 hours for sure. So one technical question we got from Robert. Robert asked, does the FMSCR apply to an intrastate carrier that has a DOT number? If not, does Alabama have similar rules? And Warner, what do you think about that?
Yeah, so I probably need a little bit more information. An intrastate carrier and an interstate carrier are both going to have a DOT number. For the most part, general rule is that if they are authorized as an interstate carrier, the FMCSR applies, even in situations where at times they're only going intrastate. Alabama does have, I think it's section 37 of our code that deals with commercial vehicles. But this is probably one that we need to get a little more information on and do a little bit deeper dive in the facts, and we can kind of work through what is applicable and what's not. And David, just for the quickness of it, I can see the question as well. I don't have a problem, and everybody feel free to log off now. It's been more than an hour, but I don't have a problem with just talking about it if you want me to.
Sure, that'll be fine. Well,
yeah,
we did get a question from William, who asked, in a big truck case, do you always file suit in clear liability cases? Would a conservative venue make you less likely to file? What do you think, Warren?
Yeah, so sometimes it depends on the kind of injury. If I think that it's a clear liability wreck with a significant injury, when I say a significant injury, I mean an obvious injury. I think there's significant injuries that are obviously significant, and then there's significant injuries that insurance companies tend to downplay. The herniations, the soft tissue stuff can be permanent and be significant injuries, but a lot of times the insurance companies don't give them the full attention they need. In that kind of case, I'm just going to go ahead and file it. There's no reason to beat around the bush. The insurance company are going to value it the way they should, and there's no reason for me to waste my time. For some of the more obvious injuries, I may send a demand and try and get something settled early, but a lot of times what you run into in that circumstance, especially recently, is there really isn't a mechanism to hold their feet to the fire like you do when you have an interrogatory, which is supposed to be sworn. I don't know if they're telling me all the insurance they have or not. And so sometimes that's a risk you run if you don't file and get something on the record that is in a sworn state. You may be risking missing out on some insurance money there. But for the most part, I think, yeah, I'm going to go ahead and file a case. And for the most part, too, conservative counties versus really good counties, to me, that changes somewhat the value of the case, but not as much as it used to. I used to be afraid of conservative counties. I'm not anymore. I have to restructure my value. A case in Lowndes County may be worth $10 million. Take that same case in St. Clair, in Alabama, those are really good county versus a really bad county for our Georgia people. That case isn't going to be worth $10 million in St. Clair County, but it doesn't mean it can't be worth more than $1 million. And it's going to change the way that I address the case. It's going to change the arguments, right? You're not going to, I think it's impossible over a week or two, which is what a trucking case usually tries for. I don't think it's possible to change a juror's mind, right? But you can frame your case in a way that appeals to the thought process and the beliefs those jurors already have. And so when you're in a very conservative county, you've just got to understand that going through. And if you've got a case that you think something was wrong, a conservative juror is going to be just as upset about, negligence in terms of a safety violation as anybody. They're going to be a little bit more work on damages, but they're going to be upset with the trucking company too if you prove the trucking company knew they did something wrong. So I'm not as concerned with conservative versus versus good counties as I was. You have to take into account, you have to understand what it is. You have to frame it. The older I get, the more I do this, the more I realize casework is just about winning the framing argument. If you can frame the case in a way from the very beginning, from voir dire on, you frame the case in a way that the juror is looking through your lens to evaluate the evidence and what the evidence means, you're going to do all right. If you let the other side set the picture that they view it through, you're not going to be doing a good job. So the lens or the frame for a conservative juror is definitely different from a juror in Demopolis, Alabama. But that doesn't mean you can't use that lens and get a good verdict. And then I think the last case, I'll answer this briefly, even though it's off topic. So Jeremy asked a question about slip and fall cases and how do we get over the prudent person standard, meaning a prudent person would have been watching where they are walking. And I think the best answer to that, and this mindset applies to trucking, it's in all cases, so it is a little bit relevant to this as well. Why do you think a person has to be watching where they're going? Right, I'm questioning the premise of that statement. Right, the other side's making an argument. The other side has a defense. The other side has a strategy. The other side has an argument. Ask yourself if they're right about that. First off, are they right? Should a person be looking where they're going? And that's a weird thing for me to say that way, but I think if we look at it from a very rational perspective, how bad and dangerous would it be if everyone walking around outside was only looking at their feet? I mean, imagine everyone walking on the sidewalk looking down at their feet. They'd run into everything. They'd run into traffic. They wouldn't see what's going on around them. So, watching where you're going doesn't mean looking down. That means looking all over the place. It means knowing where the cars are as you cross the street. It means knowing what color the stoplight is. Is it a red hand or is it a walk sign when you're crossing the street? I mean, your eyes got to be up and is there anybody coming? Am I going to run into anybody? I mean, what's going on? Am I talking to someone? And the defense for that, right, is they've got to prove that your client was negligent in the way he was walking. They don't get to just say he wasn't perfect. They got to prove he did something wrong. And what is wrong with walking with your head looking forward? And when you're looking straight ahead of you or talking to a friend, you're not looking down at your feet. That's not wrong. That's reasonable. Now it'd be different, and I think you should talk about this in voir dire in a slip and fall case. I'm walking down the sidewalk. Well, hell, it says walk in the damn name. That's where you're supposed to walk. If you're out, and this is something that Keith Mitnick talks about with Morgan & Morgan. I think anybody who drives cases should listen to him, but he's absolutely right about it. If you're walking through a scrap yard, there's rusty things sticking out doing whatever. Yeah, you got to be looking at every single step you take because you never know what's going to happen. You're going to step on some sort of metal thing. Maybe there's a raccoon in the engine of some car. I don't know. But you got to be careful. When you're on a sidewalk that's supposed to be flat and designed for you to walk, you don't need to be looking down at your feet. In fact, it is counterproductive to do that. So you've got to start establishing that idea in the jury's mind from the very beginning of the case that walking like a regular person doesn't mean looking down at every single step they take. And there is an expectation that sidewalks or whatever it is, grocery store floors are flat and safe. And so they have a reason to assume that they don't need to look down at the floor. And another thing that you could always ask is, when's the last time anybody in the jury just straight up fell down for no reason? I mean, without applying a reason, you just fell down because you forgot how to walk right. Right? I mean, anytime someone falls down, it's because something happened. They tripped on something, they hit a dip, something unexpected came up. It's not like people just forget how to walk. Right. So frame their mindset in this idea that it's not about him being perfect or people being perfect. Everybody knows how to walk. It's about what the standard is and what's expected in this area. And the defendant made this dangerous. they don't get to hide behind the fact that the plaintiff was walking like a regular person and not looking at his feet the entire time. That's crazy. So that's kind of a general, when I talk about framing cases, that's what I mean.
Right. Yep. Know your audience and adjust your arguments accordingly, for sure. And I'm afraid we're out of time. I do need to go over a few CLE announcements before we officially sign off. So for those of you who may have missed our earlier announcements, by the end of this week, you're going to receive an email with a certificate of attendance and an updated presentation and video link. You can email that completed evaluation form to webinars@beasleyallen.com. Again, for those Alabama and Georgia attorneys who are participating today by phone, please email us your name, phone number, and state bar ID number to webinars@beasleyallen.com. That'll help ensure that you receive full CLE credit. Very important. Again, be sure to check out the events page of our website, beasleyallen.com/events, as we're going to be adding more webinars throughout the year. To the extent we weren't able to get to your question today, again, reach out to our speakers today. They will be more than happy to take your questions, get on the phone with you, walk through particular issues in your case. I mean, that's what we're all about. We are all about helping each other, working in a collaborative way as lawyers, because after all, we are all fighting on the same team, and we're fighting on the team of justice, and we're here to help you in any way that we can. So thanks for joining us today, and thanks for supporting our Beasley Allen webinar series. Until next time, I'm David Byrne. Have a great day.